with the College this is a joint event with the College of Law and the Asian Australian Lawyers Association, and we're very lucky today to be joined by a representative from the Asian Australian Lawyers Association. We'll be telling you a little bit about that organisation in a minute. My name is Wenny Yap, and I'm a legal journalist with the College of Law, and I'll be moderating this session today. Now, today we are very, very fortunate to have three stellar lawyers with extensive experience in international commercial law, and many of them have a particular focus on the Asian region and in particular China, which has been personally very interesting as I've been studying under a few of them. So we'll be speaking to each of our panelists about how they came to practice or specialize in international commercial law, what skills you need to thrive, and how you can raise your profile as you venture into this area. Firstly, though, I'd like to introduce Melina Astana. Melina is the National Vice President of the Asian Australian Lawyers Association, or ALA, and she's also the Vice President of the Law Institute of Victoria. Prior to this, she served as the President of the International Law Association Victorian Chapter and has previously practiced in India. Melina will now provide a bit of an overview about what ALA does. So over to you, Melina.
Thank you, Benny. And thanks to the College of Laws for partnering with us on this event, which promises to be an excellent discussion. I'm looking forward to it as well. As mentioned before, the Asian Australian, I'm the Vice President of the Asian Australian Lawyers Association. ALA, as we call it, is a national not-for-profit organization that was founded and is run by practitioners who volunteer from across Australia. ALA is the first incorporated association in Australia to focus on the growing number of Asian Australian lawyers in the profession. At our core, ALA is fundamentally committed to promoting cultural diversity in the law. Our work and advocacy is guided by our objectives and the voices of our members. Our objectives include bringing together members of the legal profession of Asian heritage and cultural background and others with an interest in Asia. So we're not necessarily limited to people of Asian backgrounds. We provide a cohesive professional network to advocate for and provide support to our members and to benefit from shared learning experience. We improve the capability and reputation of the members in the legal profession through raising public awareness and providing education. We develop skills with Asian legal associations and facilitate the promoting and promote access for members to Asian legal markets. We also promote and facilitate Asian cultural diversity in the senior ranks of the legal profession, and we promote a mutual understanding of Australian and Asian legal systems. And that's pretty much our purposes. In terms of our structure, we have a national executive and branches in all Australian states and territories. The last to join was Northern Territory this week, and which makes us truly national. We have over 1,300 members, and we welcome members from all walks of legal life, including law students, lawyers and principals from small, medium, and large firms, barristers, in-house counsels, and government lawyers. ALA is proud that our membership represents a cross-section of the rich intersectional diversity of the Australian legal profession, given that we advocate for a legal profession that reflects the communities it serves. Some of our key events and initiatives have been the mentoring program, which has paired up over 250 mentees with mentors in 2021. The William Arquette Scholarship, which encourages thought leadership through provision of $8,000 in cash prizes for the best papers on topics relating to equality, diversity, and the law. The National Cultural Diversity Summit, which provides a forum for thought-provoking panel discussions and practical guidance. We had over 600 registrants and 300 attendees this year, and fabulous speakers from across the world. And the Cultural Diversity Snapshot, which we conducted in 2015, provided the first quantitative analysis regarding the extent to which Asian Australians were underrepresented in the high echelons of the legal profession, thereby demonstrating the existence of a bamboo ceiling, as we call it. We also hold cultural celebrations like the Lunar New Year and Diwali. In the last few years, we have really ramped up our advocacy work as well, and we have a number of projects lined up in that space, including a fresh cultural diversity report, regular opinion pieces for media, joint advocacy with other culturally diverse law associations, diversity narratives, and the foreign qualified lawyers portfolio. This is just some of them. We have a huge list of things we are working on. So if you're interested in joining, please go to our website, www.aala.org. and you can join online. But a heads up that our website is down this week as we are in the process of upgrading it. But we can, after next week, it should be fine. And thanks again to the College of Laws, and we hope that we will see some of you again, perhaps as members of AILA. Thank you.
Fantastic. Thank you so much, Melina. I think it sounds like an excellent organization. And honestly, it's one I wish I'd known about when I was starting out many years ago. All right, so let's get started. To give you an idea of how today's session is going to be run, it's quite free form. We're going to hear from each of our panelists about their career journeys in international commercial law. The chat is open to you to ask questions throughout, and please do, and I'll be guided by what you ask in terms of what we cover. So before we dive in, let me introduce who's going to be speaking to you. So firstly, we have Martin Pillane. He's a practicing barrister with 35 years experience as an arbitrator with extensive experience in the Asia Pacific. Martin was instrumental in developing the college's international arbitration program. And as I mentioned, in fact, I'm one of his students. Our next speaker is Professor Don Lewis. Professor Don Lewis has spent his career in Chinese law, teaching Chinese trade and investment law at Stanford, teaching extensively at the University of Hong Kong, and as a US Fulbright Law Professor at Nankai University and Zhongshan University. Professor Lewis works closely with Martin, teaching international arbitration, and he's developing a series of other courses too. Raphael Tay is a partner at Law Partnership in Kuala Lumpur, where he heads their corporate and commercial practice group. Prior to joining Law Partnership, he was a partner in another major law firm, and he was recently appointed to the Law Asia Executive Committee in 2020. As I mentioned, I'm a legal journalist at the College of Law. I'm also very involved in marketing for legal tech, legal services, and for legal educators. And that's involved work with legal software, Legal Vision, the Dockyard, and most recently, the College of Law. But enough from me, let's get started. As I said, please pose any questions in the chat box and we will address them as we go. We'll also finish up around 5:45 with a dedicated Q&A, and we'll have a hard finish at 6 p.m. So thank you very much for joining us today. Straight after work, we really appreciate having you here. All right, so we'll just go around. Our very first question is a very broad question, and I'll pose it to each of the panelists. What does your career actually involve? How did you come to practice in international commercial law? And if I could kick that question over to Raphael to start us off.
Thanks very much, Rini. Really it's a delight and privilege to be here with you this afternoon, this evening. I'm speaking to you from Kuala Lumpur. I started my career, well, I've been in practice also for about 35 years now. But the international element of the practice probably came about 20 odd years ago. One of the things that we realized, or I at least realized at that time, was that I was getting a lot of briefs, a lot of instructions from corporate law firms from around the world, particularly in relation to the work that they do in Malaysia, Singapore, and within the region. The funny thing is that for many of these law firms, international law firms that at that time didn't have Asian or Pacific region law offices, they really didn't know where Kuala Lumpur was or Singapore was. Well, perhaps, sorry, I correct myself. They probably knew where Singapore was, but they didn't know where Kuala Lumpur was. And so sometimes I get briefs that was meant for Thailand and for Myanmar and some of these other jurisdictions. So I saw that there was a market, there was a niche for this, and I very quickly, developed those soft skills required. This was over a period of time, and this wasn't mentioned, but over a period of time, I acquired quite a bit of practical knowledge, information in the ASEAN region. So apart of being a teaching fellow in the College of Law, I also teach at the Chulalongkorn University. A topic called ASEAN Business Investment Laws. That's briefly the sum total of what I do in international commercial practice. I don't do the arbitration dispute resolution portions of it, but it's more of the transactional advisory portion of international practice.
Thank you, Raphael. That makes a lot of sense. Martin, you do the arbitration and dispute resolution side of it. You're based in London. How did you come to be involved in this?
Thanks, Winnie, and a pleasure to be with you today. Well, I never intended to be an international lawyer or indeed a commercial lawyer, I was always set on being a criminal advocate. I think like a lot of people as a young man, I saw TV programs with barristers with wigs and robes standing up, and I thought, oh, that looks good. I'd like to do that. So I became a criminal advocate, and then really by chance moved into international law. In my early years, I mean, like Raphael, about 35 years experience. In my early years, I had a junior brief in a large fraud case involving a number of corporates. It stretched across the world in the issues it raised, and that really exposed me to international practice. On the back of that, I started getting instructions in other cases that had an international angle, and then got some representational roles with some regional and international organizations. And it really moved on from there. So I found myself moving away from criminal law into the areas I practice today. So public international law, commercial arbitration and state investor arbitration. Also advising both corporates and individuals on regulatory and compliance issues, because there's a real overlap with commercial law there. So I'd like to say that there was some career plan. I'd like to say this was all planned out, but it wasn't. And I think one of the lessons that I take from that is literally seize the opportunities. Sometimes you never know, you might just be in the right place at the right time. So sometimes go where your intuition leads you.
That's good advice. And just over to Professor Don Lewis, you have taken a completely different route to our other two panelists today. How did you find yourself as a specialist in international commercial law, especially in Asia and China?
Well, it's a long story, actually, when you mentioned how did you come to practice international commercial law, I mean, it hasn't been really that much in terms of practice. There has been some, but it's actually been my involvement in the legal academy, in law schools over the years, and in some cases, think tanks. But this did actually, I mean, in a way, yes, it began sort of serendipitously. I mean, I obtained my LLM from the University of London from SOAS many years ago. And the University of London had just begun offering courses in Chinese law. So when I began, the Chinese legal system was very, very young. And indeed, while I was studying in London, I met the Venerable Lord Denning, who many of us, of course, know of, at a social function in London. And he asked me what I was studying, and I said, "Oh, it's Chinese law." And he said, "I didn't think we taught that subject in London." The Chinese law has come a long way, and I suppose I have too. After graduation from London, I secured a research position, research fellow position, actually, at the East-West Center in Honolulu, Hawaii. And my first boss, who then became my mentor or Daosher, was Dr. Victor Hao Lee, perhaps the leading Asian American law professor at the time, who gave up a chair at Stanford Law School to become president of the East-West Center. I mean, that was a remarkable time, really sort of the early 80s, just as China was opening up. It eventually led to me becoming one of the first US Fulbright law professors in China, and indeed the youngest at the time, back in, dare I say it, 1984. And as you've mentioned, I taught at Nankai and Zhongshan, or Sun Yat-sen universities in Tianjin and Canton, respectively. So unlike what Martin said about his own career path, I mean, once I got on this track, it's been pretty much sort of you're on a train and you're going to the next station. After my time in China at these universities and teaching in their law schools, I then sort of moved on, and fortunately, very fortunately, serendipitously, in fact, I was offered a position at Hong Kong University Faculty of Law back in 1986. And at that time, Hong Kong University was just opening up a whole new program on Chinese law, and indeed at the same time an LLM program, which included Chinese law, but also international business transactions, other transactional subjects, and I also teach in the areas of international trade law, international investment law, and the like. So it was a remarkable opportunity, and I stayed at Hong Kong University for 23 years, the longest serving American in the history of the faculty, and then finally returned home at the invitation of Stanford Law School in 2009 to teach Chinese law subjects at Stanford, very much like my mentor, Victor Lee, had done many years before. So I think that's probably enough background on me.
I think there's a real through line through all of your stories, and thanks very much for that, Don. About serendipity and following your inclinations, your passions, and in many ways following where the work was leading. And I think that's really come through for all three of you. Now, down to sort of brass tacks, as they say, what does a day in your work life actually look like when it pertains to international commercial law? And we'll pop through in the same order if that's all right with all of you. So Raphael, what does your day-to-day look like? I mean, I know you're going into client meetings straight after this, so fairly busy.
Thank you very much, Winnie. Yes, well, I dare say that most of us would probably have a common theme, and there is time is not ours. For us that practice international commercial practice, a lot of the time is actually dictated by the client. So I started the day fairly early, about 7 a.m. I'm in the office or in my home office, checking the emails. And I do that consistently throughout the day. There are meetings to attend with clients. But there's something else which perhaps because of time zones, I get a lot of instructions from Europe and Americas past 8 p.m. Kuala Lumpur time. So I will need to monitor those emails that come in, and if it can wait, then I'll reply the next day, the next working day. But very often, many of these things cannot wait very long. So you really need to be very quick, respond, just say noted, we'll look into this and we'll revert back to you. Because I think people, lawyers that gives you instructions, like to know that you have received it and you are attending to it. So I do that throughout the course of the night until I go to bed about 12 midnight. But on certain occasions, I wake up in the middle of the night to ensure that certain emails that I expect to come in are attended to. So practically, I would say it's a long day, but it's an enjoyable day because this is what I enjoy doing, and it's a passion. And I think that's important. I think if you want to be involved in international commercial practice, you need to have a passion for it, and you need to lock in the hours.
That makes a lot of sense, and I think it makes sense across time zones and aligning in that sense as well. You have to have the passion for it, and you have to be able to log the hours. Martin, would you agree with that? And around the time zone issue and alignment, the time's not always yours.
That's very true, particularly, of course, during the pandemic, given that we've been spending a lot of our time using Zoom or Teams and platforms and having to work at the client's time zone. I found myself, for instance, with a few weeks back, I had a whole week where talking from London, my working day was midnight to 8 a.m. And a couple of weeks ago, again, a few days where it was sort of 1 a.m. to 9 a.m. So you have to adapt to the time zones. Normally, of course, pre-pandemic, I find myself doing a lot of traveling. I think over the years, I've probably worked in something like 80 to 90 different countries. So although Asia and the Asia Pacific region is my main focus, I also do work in sub-Saharan Africa, Latin America, Europe. So a lot of traveling normally, which has got its pluses, but has also got its minuses. One has to avoid just going from hotel room to hotel room. I think that's one of the keys, and actually immersing oneself where one can in local society and culture. My day tends to be a bit of a mixture. Like Raphael, I like to start early. I like to start at 7 a.m. or beforehand. Sometimes it's advice. I mean, I find myself advising countries on treaty obligations, on international instruments, clients, individual or corporate clients on contracts, on disputes, obviously with arbitration. Sometimes it's representational roles. A number of countries around the world, particularly small jurisdictions, don't have in-house expertise in international law. So I found myself representing those countries in some of their negotiations, either at a regional or international level. Then, of course, there's the advocacy. I'm still at heart an advocate. So typically now an advocate in tribunals, in arbitral tribunals, sometimes, in fact, sitting as an arbitrator, which for me is quite interesting because I'd always shied away from the idea of becoming a judge, sitting on the bench. I think I'd find that quite lonely. I think I'm quite a sociable person. I find that quite lonely, and I wouldn't really like to sit in judgment on someone. But for some reason, I'm happy to sit as an arbitrator. So perhaps a little bit inconsistent and odd on my part, but there we go. So the days are varied. I mean, that's one of the nice things that I find, that if I look back over my career in international law, the time really has been very varied. Literally no 2 days are like each other. I think as Raphael was saying in relation to emails, I think that notion of responding very quickly, reacting to what the client needs is key. Timeliness is so important. I think if you get a reputation for meeting deadlines or even beating deadlines and being timely, that's incredibly valuable because people recognize that. As a barrister, your instructing solicitors recognize that. As a lawyer generally, clients appreciate that, particularly in the commercial world, where obviously commerciality as well as issues around law are so important for both lawyer and client.
Thank you, Martin. That does make a lot of sense, that one needs to be extremely timely. And this is particularly a challenge as you enter international commercial law and you deal with different clients in different places. And for this question, I'd like to kick it across to Don. What does your day-to-day work life look like? It would look quite different, I suspect, from Raphael and Martin.
You're absolutely right, Winnie. It is quite different because I'm a law professor, a legal academic, and in terms of how I conduct my day is to some extent, and not entirely, of course, something I can structure according to my own, my own plans, my own schedules, and the like. So I am able to do that relatively freely. I do, of course, have a structured way in which I proceed. I mean, as a law professor, of course, what one doesn't see is just how much research goes into, even giving a tutorial or a seminar, as we're doing currently in the International Arbitration course for the College of Law. So lots of research, some online teaching currently. I'm also involved currently with the Law Asia mooting competition. I do enjoy mooting competitions. I've acted as an academic advisor or coach for teams, in China, in Hong Kong, and in particular, places such as the University of International Business and Economics in Beijing, the China University of Political Science and Law, also in Beijing, Hong Kong University in Hong Kong. And this has involved mooting competitions such as the VIS, International Commercial Arbitration moot, the FDI moot and the like. So a lot of involvement in those over the years. Also, of course, public speaking. As a law professor, I'm often called on to speak publicly or through interviews. I work on publications. Just had a recent publication for the Journal of International Business Policy on essentially the intersections, the synergies between China's Belt and Road Initiative and the UN Sustainable Development Goals. And then, of course, I also have occasional legal consultancies working with law firms, and also drafting expert opinions, typically for courts. I've produced expert opinions on 4 continents, including Australia, I should say. And so this all keeps me hopping at a pretty brisk rate, notwithstanding the so-called academic freedom I'm supposed to have. But I would point out too that one of the great advantages, which I in some ways pity my practitioner fellow speakers, is that the academic life allows one, as I've mentioned, a fair amount of academic freedom to delve much more deeply into specific areas of law. It's not so, it's not predicated on billable hours. So, and so as a result, I also get to see the bigger picture. This is when I was in practice previously with a firm in Hong Kong, I could see how sort of limited their vision was, because they had to get the next memo out or prepare a brief of one sort or another. Whereas as an academic, I was able to look at the bigger picture, and indeed I see where different legal domains intersect. I've been able to engage in multidisciplinary research and collaboration. For example, I have worked a lot with international economists and those in international business, as well as with many China scholars in history, literature, and political science, not just law, from different countries, and of course, including China. So it's been a very, it's a colorful, variegated background that I come from, and which of course also influences the way I organize my day-to-day routines.
Thank you, Don. That does make a lot of sense, and is so different to what practitioners would need to do. Being able to take that higher level view is very much part of the academic freedom that we as academics enjoy. We've just had a question come through from Glenda Fu, so thank you for this question, and I'm going to kick it over to Raphael. Glenda has asked, would you say that knowledge of law systems in other countries is important to your practice, or do you tend to normally advise on Malaysian law regarding international transactions? How much do you need to know about a different country's laws? This could be endless. I suppose that's really the underlying question.
Thank you very much, Glenda. It is critical that you understand not just laws of your host country, but other jurisdictions. But I'll tell you a little secret, if you can call it that. When I first started practice dealing with international law firms, it all started off because they wanted me to advise on Malaysian law, because I'm licensed to practice in Malaysia. So that's how it started. After a couple of years, I began to see that actually, if I wanted to venture into international commercial practice, I needed to have some working knowledge of other jurisdictions. Now, so would I choose Australian law or English law or American law? No, because you really need to choose jurisdictions where you are closest connected with. And so I chose Southeast Asia. So I began to read up a lot on the laws of Southeast Asia, Myanmar, Vietnam, Indonesia, Sri Lanka, because I did work in Sri Lanka as well, and the rest of the ASEAN region. But it is just to understand, to have a bird's eye view as to how these jurisdictions work, how they approach different issues. Because ultimately, being an international commercial lawyer doesn't mean that you are licensed to practice in multiple jurisdictions. In fact, you'll find that many of the most foremost international commercial lawyers are not licensed to practice in multiple jurisdictions, maybe one or two, but they have equipped themselves sufficiently to understand what the right questions to ask and how to approach each issue or problem that arises. So subsequently, because of the knowledge gain, I'll just tell you this, that I had Korean law firms appoint me, who is based in Kuala Lumpur, to act for them in Vietnam, in Sri Lanka, and in Philippines. Now, I was very intrigued. So I asked this lawyer of mine, a friend of mine who was instructing me from one of the large Korean law firms. And I said, why are you instructing me? And what was very important, and that brings perhaps to the next point, is that there was an element of trust, because I had worked for them, for this Korean law firm, vis-a-vis their acquisitions in Malaysia. So they liked my work, they liked my approach, they liked my timeliness. And then they began to understand that as a Malaysian lawyer, who is a common lawyer, a Commonwealth lawyer, a common law jurisdiction lawyer, I also understood many of the other common law jurisdictions, like in Sri Lanka and so forth. Now, of course, Philippines was slightly different, because Philippines law is very much influenced by American law and also by his Spanish origins or past history. Indonesia was another country. I mean, much of the Indonesian law today is actually Dutch civil law. So it is understanding these principles that will help you. And this Korean law firm then said to me, you speak good English, you understand international practices and transactions, and you understand how we Koreans expect to be treated. Of course, I mean, that's a different chapter altogether. Korean law firms' expectations are just beyond this world, actually. So really just understanding that, and just being able to explain to the Korean lawyers what exactly they had in mind. Perhaps they didn't have the vocabulary or understood common law principles or terminology. So it's very important to be able to explain to them in a manner in which they can understand. The other thing in international practices is that do not be misled by the common use of terms. Very common terms may mean different things in different jurisdictions, different cultures. So I think that's the other element which you need to understand. So to understand Gwen's question, I practice both Malaysian law as well as the international element of international practices without being licensed to practice in Vietnam, Sri Lanka, Indonesia, or Philippines, but just knowing enough about the different legal systems to ask the correct questions and dissect those answers to be able to advise the client.
Makes sense. So basically you have enough of the building blocks of adjacent legal jurisdictions to provide cogent advice. Yeah, that makes sense. And actually, as a follow-on to that, which is one of the questions we were going to explore anyway, what about the cultural dimension, the cross-cultural dimension? You started to allude to it regarding the Korean law firm, but what kind of cross-cultural considerations should lawyers, particularly Australian lawyers, that's a lot of the lawyers here with us today, take into account as they consider a career in Asia? For example, do they need to know all the local languages? As Malaysians, we might know 4, but do you need to know Mandarin? I know Don knows Mandarin, or any other local languages. What other things would you want to look out for from an Australian perspective going to Asia? What are some common mistakes we might make? And that could be to you, Raphael, Martin, anyone. But Raphael, please kick us off. You're smiling.
My advice to the Asian Australian lawyer or the Australian lawyer is this: empathy. I think empathy is one of the keys. Martin will tell you that, because I worked with Martin. I've not worked with Don, but I certainly worked with Martin. And Martin will confirm that. And being able to empathize with the foreign counsel, with a foreign client, with different foreign cultures is actually very important, without being judgmental. Because, I'm often amazed when people tell me that, oh, it's universal. Love is universal. Yeah, I agree with you. Love is universal. But how does this love translate and play out is very different in different jurisdictions, different cultures. So it's very important to understand that whilst we all like to embrace diversity and say that there is a universal language in terms of human rights, in terms of love, in terms of needs, there is also the subtleties of how is that transformed how is that played out in different cultures? In Asian cultures, for example, very few parents, but of course increasingly the younger generation practice that, will never would never, what do you call, boast about their children in front of the children. You know, when a child comes back with an A grade, it's like, oh, is that all? Can it be an A plus? You know, whereas when they go out and they are not within a year short of the child, it's like, my child, my son, my daughter is quite brilliant actually. But those things are changing, of course. Yeah. But I'm just giving a small example to explain that really all these things, whilst there is a universal need of love, of human rights, how it is actually understood might be quite different. I know Martin has got a lot to say about this because we have worked together in some of these issues.
Martin, so would you say the way in is empathy if you're navigating completely foreign culture?
I would agree entirely with what Raphael said around empathy. Yeah, absolutely. And I think what I would say is this. I think going back to Glenda's point, Glenda's question, I think there's the legally cross-cultural and there's the wider society issues around cross-cultural considerations. I think from the perspective of the lawyer, you need to understand the different legal cultures. You need to understand common law and civil law jurisdictions, how they work. So if you're a common law practitioner, you need to really understand how that civil law system works and vice versa. Because, for instance, in international arbitration, in the field I practice, you may find yourself in a multi-jurisdictional team. So you may be in a team as a Malaysian lawyer, a Singaporean lawyer, a UK lawyer, with, for instance, lawyers from perhaps France or Spain, or perhaps from the US. You may have different professional obligations. I mean, for instance, on disclosure issues. In common law jurisdictions, we spend a lot of our time worrying about disclosure and discovery. In civil law jurisdictions, the starting point is disclosure is prohibited. And in fact, it would be a disciplinary offense for many civil law practitioners to actually disclose material to the other side. So you need to have that understanding. I mean, I sometimes find that if, for instance, I'm sitting with an arbitrator who's from a civil law jurisdiction, they might feel very uncomfortable if there's very vigorous cross-examination or hostile cross-examination. So you need to be aware of that, whether you're a party representative, whether you're an arbitrator. So I think the legally understanding is key. And then culturally, as Raphael said, yes, I think it's vital to understand how a society operates, how a society ticks, and also the expectations, the cultural norms. I was lucky; I had the benefit of a Chinese Malaysian wife, so that really helps. So all my faux pas, all my things I got wrong, I tended to get wrong at a very early stage when I first met her. So that actually helped in relation to my legal practice. So I think it is important, and the example Raphael gave around parents and praising children, I think is a really good example. Of course, from the dispute resolution standpoint, it's particularly interesting because from other parts of the world, one sometimes thinks about being very aggressive, bombastic, etc. in some dispute negotiations. Within Asia generally, and certainly within ASEAN, of course, there's the notion of not losing face. There's the idea of trying to reach a settlement that each side can live with. And I think that takes a different mindset, a different approach, and you have to be alive to that. I think also, as a young lawyer building your career, for instance, if you're an Australian lawyer looking to build your career within Asia or the Asia Pacific region, I think one of the other issues is face-to-face meetings, face-to-face contacts. I think particularly in the modern world, particularly in the pandemic world, we're doing a lot of things by email or by Zoom calls out of necessity. I think for Asia, it is important to have those face-to-face meetings. I've lost track of the times where if I've made contact through email or through a letter, there's been no response, no engagement. But if it's actually been getting there and being face-to-face with somebody and meeting someone, having that interaction, then I think that's vital, because I think for Asia Pacific, it is building that personal contact. I think it's true generally. I think in reality, whatever parts of our lives we're looking at, we like to do business with people we like. So I think that carries through with the legal profession and with the relationship between lawyer and client. So yes, and I think summing up as Raphael did with the word empathy was entirely right.
Thank you, Martin. So to sort of carry that through, we like to do work with people we like, and I think a lot of the people that are here with us today would then ask you the next question, which is, well then, how do you become one of the likable people that enters international commercial law? How should they network, raise their profile, go about getting that first opportunity in international commercial law? As we've all talked about before, Australian lawyers are not always that connected with our region. And obviously everyone who's attending here today is keen to change that. But where do they start? How do you network? How do you raise your profile? How do you make those connections? And happy to keep that to anyone who would like to answer.
Winnie, can I just start off?
Please.
I think one of the things that we have to understand is that from an Anglo-American legal profession perspective, you will see that the largest law firms in the world are typically Anglo-American.
Mm-hmm.
Australian as well, of course. But of course, Koreans now, of course, Korea has got very large law firms. Japan has got very large law firms. But the bulk of law firms and a lot of international commercial practitioners do not necessarily come from the large law firms.
Oh, interesting.
That is a very interesting fact, because in a lot of these jurisdictions, in Thailand, in Sri Lanka, in Vietnam, many of these jurisdictions, and including Japan and Korea actually, you do find smaller law firms, 50-member fee earner law firms, which is small in Korea in terms of Korean large law firms, are actually out there doing international commercial practice. How do they do that? I think one of the little advice I can give to young lawyers is that you really need to get out of your comfort zone. In other words, if you are not in a major law firm or a large law firm, you need to do something for yourself, and that is attend international law conferences. Because it is by attending international law conferences that you get to meet other lawyers. Mm-hmm. And if you are a likable chap, I'm not necessarily saying that you must be able to drink like a fish, but it helps. If you're a likable chap, at some point in time, someone's going to say, where are you from? What's your law firm? What do you do? And don't be embarrassed by just saying, I don't come from a major law firm, but this is what I do. This is what I hope to do. And I hope to be given some opportunities to do that. Mm-hmm. You don't ask, you don't get. In other words, apart from being able to empathize with others, you must not be judgmental and arrogant.
Yes.
I think humility is very important. No one wants to help someone who's arrogant, especially a fellow lawyer. Fellow lawyers like to help other lawyers that a little bit more humble, a little bit more desiring of wanting to learn and so forth. So I think that's important. Attend international conferences. There is the IPBA, there is the Law Asia, there is the IBA. But of course, the IBA is a huge organization, and I think Don will attest to that. I mean, having attended IBA conferences, you get lost because it's thousands upon thousands of delegates. For the Asia Pacific region, I think the Law Asia and IPBA is probably more suitable in terms of size, because it's not too large and you still get the opportunity to meet and mingle with other people. So I think, yes, get out of your comfort zone, go out and meet people, attend international conferences, and equip yourself. Start, by reading up, studying other jurisdictional laws and so forth.
I think that's excellent advice. And just to add to your point, because you brought up the IBA conference, the IPBA conference, I've just put in the chat there several scholarships coming out of those conferences that could be of interest. And I know that quite a few people that we've had involved in these conversations have actually used those to springboard into an international commercial law career. Martin, what would your advice be in terms of raising your profile in international commercial law? As you mentioned, you actually came from a career of advocacy and criminal law and moved across to this particular area. How did that happen? How can our lawyers today do that?
Well, Raphael mentioned international conferences, and I think getting out there and meeting people is absolutely vital. And I think be yourself. Raphael mentioned humility, and I think that's quite right. Be yourself. Don't imagine there's some clone of a young commercial lawyer you have to be, because again, people like to engage, people like to help other people that they actually recognize qualities in. So I think that quality of humility, that quality of being someone who other people can get along with is vital. And I often see, whether I've been interviewing young lawyers or meeting them at conferences, people who actually deep down are probably very nice people, but put on, or feel they have to put on, this facade of this arrogant clone. And I think this is really dangerous and to be avoided. Sometimes people have preconceptions about what you should be to get on as a commercial lawyer. So be yourself. That would be my message there. On international conferences, I think, yes, the IBA is incredibly large. I've spoken a few times at the IBA conferences, and there's sometimes 3,500 people there, something like that. You just don't really get the sort of opportunities, I think, as a young lawyer that you get at other conferences. I would mention the Commonwealth Lawyers Association and the Commonwealth Law Conference. Obviously, a number of those probably tuning into us today will be from Commonwealth jurisdictions. So the Commonwealth Lawyers Association is, again, active, it's supportive, and there's also the Commonwealth Legal Education Association, which is worth having a look at. I think particularly the IPBA, the Inter-Pacific Bar Association, of all professional bodies that we're probably going to highlight, is a particularly collegiate one, is particularly supportive. And I think the experience of a lot of people is, if you contact, as a young IPBA member, if you contact another member and reach out, hopefully you should get some help. You should get some engagement. I think if you can find a mentor, I think that is important. And mentors come in all sorts of different ways. I know some law societies, some bars will actually have mentoring schemes that they've set up. If you get the opportunity to participate in those, great. If not, see if you can actually go out and seek a mentor. That might be through someone you've met at a conference. It might be through contacting someone out of the blue. I think that sometimes works. Yes, lawyers, we know, are often busy. Some lawyers are very bad at responding to messages, but it's worth having a go. I mean, I was lucky. I've had various mentors at various stages of my career, and that's really helped, because it does introduce you to a wider network. It does educate you, not in hard law, but in the way to build your career as a lawyer. And I think that is key. It's interesting, the point that Raphael made around smaller law firms. I think that's absolutely right. And in just about every major jurisdiction, you'll get boutique law firms who are small in size, have real degrees of specialization. Look about perhaps getting some, if for instance you're a student, perhaps getting some work experience there, some shadowing opportunities there. And I think with arbitration, it's notoriously difficult to get appointments as an arbitrator, because if you think of the nature of arbitration proceedings, they're held in private. You don't get a chance really to interact with the parties if you're a non-party. But a number of the arbitration institutions, including those in the region, have shadowing schemes, have almost something akin to pupil arbitrator schemes, particularly for young practitioners. So I think that's certainly worth looking at. The other thing I would suggest, if I was looking back thinking, what should I have done if I was going to build a career in international law that I didn't do, it would be considering at an early stage in my career, some form of secondment with an international organization, well, an international or a regional organization. So, for instance, obviously a number of UN agencies, yes, internships, placements there are very competitive, but they do exist and they're worth looking at. Similarly, with some regional organizations, there's that prospect as well. I've seen a number of examples of young lawyers who have perhaps gone and spent some time with the OECD, for instance, in Paris, who have built up tremendous commercial awareness and used that for later opportunities. So I think worth thinking laterally, perhaps some potential opportunities you wouldn't otherwise consider may be particularly advantageous going forward. I think also contact with NGOs. I mean, I think if you look at some reputable NGOs, those have high level engagement often with law firms, with government as well. So for instance, if you think about Transparency International, the big anti-corruption NGO, that has a number of chapters around the world. Those often have senior lawyers on their boards. It's a good way of getting exposed to wider issues and to meeting those lawyers. So I think laterally, and yes, certainly always be yourself.
Thank you, Martin. I think that was so valuable, and you actually raised a few that I didn't immediately think of, such as NGOs like Transparency Internationals and reaching out, and to working with international organizations such as the OECD. So I think there were some really useful pathways there. I'm very mindful that Raphael has a hard exit at 6 p.m. So I've noticed a few questions have come through the Q&A. If you're listening, please do feel free to pop in a few more questions via the Q&A, but I might actually switch gears a little bit so that we can get a few more questions out and answers out of Raphael before he has to head off. So I might go to our first question from anonymous attendee, and this person has asked that the international commercial law practice has become very competitive to break in, even with an LLM in international commercial law or a related field. And the reason I'm posing this question to you, Raphael, is because the next part of it goes on to ask, what would be your tip, especially for those coming from Asia, for people who are hoping to build a career in this field of law? So they might have an LLM, but it's a very competitive area. You come from Asia, how do you break in?
Interesting question, but I can give you some examples which I have seen myself. Now, there is a lot of law firms now in ASEAN, in Thailand, in Myanmar, in Cambodia, in Vietnam, in Laos, which have internships or are prepared to take on foreign qualified lawyers, Asians or otherwise. Why? Because these countries are rapidly opening up. They have a lot of international transactions. They have a lot of foreign investors. But they lack talent. They lack talent in terms of people within their national jurisdictions that either speak good English or another international language, whether it be French or whatever it is. But generally speaking, international practices are conducted in English. Number one. Number two, they like someone from abroad who understands cross-cultural issues, not just Cambodian issues or Vietnamese issues, but let's say you're an Asian from Australia, for example. In fact, I would suggest that if you're an Asian based in Australia or an Asian Australian, you have something that no one else has. You have the Asian heritage, your Asian connections. You may have lost some of its culture. I mean, let's be truthful about it, but at least you have the foundations of it. But more importantly, you come along with the Australian quality. So I know of many Malaysians, now these are Malaysians, they have gone to Hong Kong, they have gone to Bangkok, they have gone to Vietnam and Cambodia. But these are young men and women that were prepared to step out of the comfort zone. They were prepared to go to a smaller city like Phnom Penh, Siem Reap. They were prepared to go to Yangon, So if you want some kind of international exposure and you're trying to break in, you must be prepared to roll up your sleeves, roll up your trousers, and walk the soap. And there are opportunities. And once you have done that, you have broken into that, it's a lot easier to go up the next step. But if you're not prepared to do that, if you are in the comforts of suburban Melbourne or suburban Sydney and think that that's your entire world, well, then, you really have to have a paradigm shift in your thinking. Be prepared to go to these countries. And I have had Australian students in my LLM program that I teach in the College of Law that have gone on to places like Vietnam and Bangkok, and they are very happy because that was the break they needed. So to the Asian Australian member that's listening in, I would challenge you to pack your bags and make the move.
Especially as our borders are soon to be reopening.
Absolutely.
I think that there would be many of our audience members here with that sense of adventure. And I think you're absolutely right that you have to roll up your trousers and be prepared to go to these countries that are opening up and you'd benefit from that experience as well. That's how you break in. So thank you very much, Raphael, for that a very practical answer. It's always good to get some honesty and some real truths in these kinds of sessions. The next question, and Raphael, please, when you need to go, just we will farewell you when you need to. Our next question. Yep, no worries. Thank you for your time. Our next question, I might actually pose this to Don. It comes from Charlotte Hu. And the reason I pose it to Don is because I know he's extremely bilingual from all the classes that we do together. And Charlotte Hu has asked, how do you value bilingual skills in the international commercial practice?
Well, thank you for that question. I mean, if you're talking, for example, about China and becoming proficient in Chinese law, it becomes, really a priority, impacting your credibility. If you can't at least speak, conversational Mandarin, you should also be able to, of course, read at least 简体字 or Chinese simplified characters, and be able to read Chinese laws in Chinese, as well as, for example, Supreme Court, 最高人民法院的意见, opinions, decisions, provisions, understanding the typology, the hierarchy of legal norms in China. You have to have all of that. You have to develop all of those specializations. So, I think that, I think China is a very good example of the value and importance of language. But I think this is probably true for many of the Asian jurisdictions. And Raphael's been referencing Cambodia. I'm sorry, referencing ASEAN. I've done a lot of work in ASEAN over the years, including with Australian aid. So, I mean, becoming familiar, for example, with Thai or Khmer or Lao, bearing in mind that Thai and Lao share some 80% of their languages in common. Yes, but becoming familiar with language and its relationship to law, to national law, to national legal institutions, and indeed their idiosyncrasies. I mean, it's not a matter of just relying on the formal written law. You have to be familiar with the practices in the interpretation of that law, the practices in relation to the regulation of society and the like. And as I think some of us are aware, many that are Asians will appreciate that there is a significant gap between formal written law and actual practice. So in some ways, language helps to bridge that gap, because you're able to communicate in the local language, and to you know, forge the empathy that Raphael was referring to. This, I mean, you understand each other. You understand the culture, the larger culture, the legal culture, and as a result, you're able to understand the way in which law operates. You understand how dispute resolution operates. Martin made reference to the fact that in many Asian jurisdictions, the emphasis is on informal dispute resolution. The Confucian notion of yielding, you know, the idea of compromise, not relying on strict technical legal solutions to problems, and therefore an emphasis on tiaojie, or mediation. These are all things that come actually, in a way, through learning more about the language and ultimately the culture that you're getting involved in. So, you know, that is why language skills, the development of cross-cultural skills is so important.
Thank you, Don. Sorry, I just unmuted myself and a strange message came up. So I have a final question from Dominic Yap, and I know we've covered this to some extent already, but I thought it would be good to address this particular situation. Now, Dominic asks, how should young lawyers practicing domestic law, especially those in small firms without international exposure, make that switch? It would be an almost complete context switch, make a switch to a more international focus in their practice. And Martin, if I might pop this question over to you.
Certainly. Well, I've certainly come across examples of young lawyers in small domestic practices who, even within that practice, have begun to build up their knowledge, their informal contacts, again through conferences, etc., and have then used that as a springboard to move firms, for instance, to move to a firm that actually does international practice. So I think one can certainly equip oneself by building up the networks, by getting out there and getting known, because of course you can attend those conferences, provided you have the time and the ability to get there, whether or not you're actually at the moment practicing in those areas. I think one of the issues, and it's an issue that students and young lawyers often ask, is if you're in that situation and you haven't, for instance, got an LLM in international law, should you go down that route? Should you do that? I think that's quite interesting, because at one time, I think I would have said no, that the important thing is to just try to build up your profile as a practitioner, build up your practice. But more and more now, I think regard is had to the student or the young lawyer having an advanced degree, as is sometimes referred to, in other words, an LLM. And I think now my advice would change to what it was a few years ago. And I think I would say, get that additional qualification. It shows a level of interest, a level of commitment, and then of course it gives you the knowledge that is in fact the springboard. And I've seen specific examples of young lawyers who have started doing their own study, their own research, and then submitting papers, perhaps making comments on blogs. There's a lot of international law blogs, for instance. They've participated in those. They've perhaps written some articles for some journals, particularly some of those journals aimed at a student and young lawyer readership, and gained exposure that way. So I think it's a bit of a multi-pronged approach, but I think in reality, unless the firm you're in is going to allow you to build up a practice which is cross-border, which is international, then you would have to think about moving. And I think that probably leads on to a sort of reality now that people are moving much more generally, I think, from law firm to law firm than was once the case. Whether one was a barrister in a set of chambers or a lawyer in a law firm, it often was perceived to be a long-term commitment, a lifetime or career time commitment. That's not the case now. People move, and they move without any detriment to their careers. It was once thought that if you were a couple of years at a firm and then you moved elsewhere, that there was something odd and eyebrows would be raised. That's not the case now. I think people move. It's recognised that people will move on for new opportunities. So I think one has to think dynamically as well, which is sometimes difficult because things can be precarious and there's an element of risk, isn't there? But again, I think that's the nature of this area of practice. As we said earlier, it's very competitive. So it is a question of going out there and not just seizing opportunities, but actually sort of making opportunities for yourself as well, I think.
I think that's absolutely true, and I think it's interesting. We've talked about the LLM a few times now, and certainly it's been a pathway that I've pursued because of that particular issue of not being able to switch within sort of current workplace context. And I'd be remiss if I didn't bring up the College of Law graduate certificate in international arbitration practice, of which both Don and Martin teach. They teach very well. And also the LLM in applied law, majoring in international commercial law, that is also being developed and available. It's very much a practical pathway in to a career in international commercial law. It is quite different to what a lot of the universities offer, which tend to be very research intensive and focus on these sort of specific areas of interest to the academics involved. And that's certainly been a point of difference. So it could be something of interest. Now we're at 6:08, so we have very little time left. I might pose the very final question that I see in the chat, but please, if you're listening and you have any other burning questions, burn away and put them in the Q&A now before we run out of time. We do have another one. Sujan has asked, he said that he's a foreign qualified Nepal admitted lawyer who was admitted to practice in New South Wales in 2019. He came here to do his LLM, and he had a little bit of struggle around that experience, even though he used to deal with numerous high-profile matters, many of whom were based overseas. Would it be true to say that Australian law firms are quite conservative in welcoming foreign qualified lawyers, given the diverse makeup of the Australian population and the multidisciplinary settings that Australian lawyers practice in? Thank you, Sujan. I'm not totally sure if our two panelists can comment to that, not being based in Australia. Would either of you wish to speak to this?
Yeah, well, I'm happy to, because I spent a fair amount of time in Sydney.
Okay, great.
I think Sujan's absolutely right. I mean, the reason I wanted to take this question is some of my students have had exactly that experience. I've certainly had students who are experienced practitioners from ASEAN who have since migrated to Australia. And when I say experience, some of these LLM students that I've had have been lawyers with perhaps 15, 20 years experience, and they have had similar difficulties, similar struggles. So I think looking to some extent from the outside, although I have quite a lot of connection to Australian lawyers and law firms, I think there is generally a more conservative mentality than perhaps one would get in other regions and in other parts of the world. I think the question is then, how do we get over that? I think it's always worth approaching smaller firms rather than large firms. One of the problems I think with large firms is they have very fixed criteria for recruitment. So for instance, supposing you are a lawyer of 10, 15 years experience, etc. Sometimes large law firms will only want to take on lawyers as associates when they're newly qualified or perhaps 2 or 3 years post-qualification experience, because otherwise you don't quite fit into the fee structure, the career advancement structure. And big law firms can be very conservative like that. You might get lucky. You might find a firm that is willing to think out of the box a little bit, but I think it's rare. Sometimes the smaller firms or medium-sized firms will recognize what you bring, will recognize your experience, the connections you bring, the legal experience you bring, and will want that because it fills in a gap for them. And some of those students that I mentioned have now actually found positions and found roles, but it has been a struggle, and sometimes it's been a question of looking to other cities. So, for instance, Sajjan mentioned being admitted to practice in New South Wales. Again, I've had examples of those who've been in Sydney, haven't actually managed to find a place with a Sydney firm, and then have moved elsewhere, whether that be to Adelaide, whether that be to Brisbane, or even over to WA. So I think there is an issue. I think things are changing in the sense that I sense now when I speak with Australian lawyer colleagues, when I speak with Australian law firms, that there's a wider recognition that Australia more and more is actually part of Asia, and that the relationship between Australia and ASEAN is absolutely key. Many of those on this webinar will know that there's recent trade agreements, for instance, which have drawn Australia even closer to ASEAN. So I think that would help, because of course the drawing closer with ASEAN means, of course, the drawing closer with the rest of Asia Pacific. So, for instance, with Sajjan as a Nepalese lawyer originally, bringing that experience would be, I think, would actually be tremendously valuable to a law firm. The difficulty is getting the law firm to recognize the need they have, or to recognize the benefits that you would bring. So I think the answer is, as always, be tenacious. I mean, hang in there. But I think be prepared to say what you can actually bring. I think one of the other problems is that if it's a question of submitting CVs or resumes, one of the problems I think you have as a foreign qualified lawyer is most resumes, whether they're from a domestic qualified or foreign qualified young lawyer, tend to be the same. They tend to say very much the same things. You need to stand out. If you're going to highlight your particular qualities, link those to a particular example, because you know what it's like on a CV or resume. Everybody tells you they're motivated. Everybody tells you they're a team player. And you've said that, but so do 300 other people. But what about saying, yes, I work well in a team. Let me give you an example. Put that straight up. Here was something that I did within a legal team, let's say, that brought this case to a successful conclusion. I'm motivated because there was a file or a case in the office that was being left unattended, where nobody else was looking after it. I grabbed that and took it forward. Give specific examples. Try and stand out. And it is difficult. Try to get, even if it's an informal sort of coffee meeting with a lawyer from one of those law firms that you're looking to join, have a chat, show them the person behind the CV, the application. I think that's key. But I do recognize the difficulty.
Thank you very much for that, Martin, and thank you for such a comprehensive response, especially given the difficulties that foreign qualified lawyers have, even in Sydney, trying to get a way in, even with the small firms. I think that was very practical, and looking to other cities that are a bit more connected with Asia. I think Western Australia and Perth is a very good example. We're actually right on time to finish up at 6:15 p.m. Sydney time. I note that we have a few more questions that we haven't quite managed to cover off, and I'll speak to the College of Law if we can get those answered separately potentially. But for now, I firstly wanted to thank all of you for attending and sparing your time with to spend your afternoon with three very, very talented international commercial law practitioners and academics that we've been lucky to get to know today. If you'd like more information on what Don and Martin are involved with at the College of Law, please visit our website or contact postgrad@collaw.edu.au. They, as I said, I study international arbitration with both of them for the simple reason that it opened up a career in international commercial law that I didn't previously think would be open. And so that's my personal endorsement of the brand. If you have any other questions regarding the AALA, Melina is unfortunately had to head off a little bit earlier, but as she said, please get in touch. Go on the website once it's back up next week. There's a number of opportunities to connect, even if you're not Asian by background, to connect with like-minded colleagues in the region. Right. Once again, thank you very much all for joining. That concludes our Careers in International Commercial Law webinar, and I hope that you found it helpful, and hopefully we might see you in the corridors of the College of Law soon, the virtual corridors. So thank you again, and I hope you have a good evening.
Thank you, Winnie. Thank you, everyone. Thank you.
Thank you.